So welcome back, everyone, for panel 3 of day 2. It is my distinct pleasure to introduce my good friend, Professor Mohamed Abdel Wahab, who will chair this panel. Mohamed is the founding partner at Zulficar and the head of the groups of international arbitration, construction, and oil and gas. He is not only an exceptional arbitration practitioner and arbitrator, but a distinguished academic, being the chair of the private international law department and professor of international arbitration at the Cairo University. Impressively, Mohamed holds a host of public positions of trust and has achieved several distinctions in his career. I will only focus on a few of them, as otherwise I would have to take most of panel 3's time. Mohamed is the vice president of the ICC International Court of Arbitration. He is a member of the ICA Governing Board, the vice chair of the IBA Arab Regional Forum, and the dean of the Advisory Council of the Africa Arbitration Academy, as I say, among other distinctions. It is a pleasure to have you, Mohamed. The floor is yours.
Thank you very much, Professor Bricolakis. It's such a great pleasure to be part of this event. Let me first start by congratulating the organizers on the timeliness of this event. And I must say that there is something that I noticed from the webinars that have taken place because of COVID-19, is that we have had more people on board, researchers, young practitioners, who are now able to join these webinars because physical conferences costs were quite prohibitive. So I think COVID-19 has opened the doors for more and more promising young practitioners to join this, and I'm very grateful that this is happening. And it's such a great pleasure to be with you today, and I'm very grateful for the kind invitation and the very gracious introduction by Professor Bricolakis, who is really a world-leading arbitrator and practitioner and academic. Let me first start by saying that I have a star panel, and I can't claim the credit for putting them together. It's the organizers who take all the credit for that. This star panel will be focusing on Africa as a seat of arbitration and local court support. We've all listened to the seminal keynote by Justice Chibita in this respect, and the importance of enforcement of arbitral awards generally, and the support local courts can give in complementation and not in direct competition, as people may think, to the arbitration process. Let me start by introducing my speakers today, which I very much will enjoy listening to them. Paula Hodges, QC. To borrow Stavros' words, we can stay days talking about Paula and her contribution to the world of international arbitration. Paula heads the global arbitration practice at Herbert Smith Freehills, with over 30 years experience of advising on international disputes, particularly in energy and natural resources sectors. She specializes in international arbitration and has represented clients in many jurisdictions, including Africa, Asia, Australia, Canada, France, Russia, the CIS, Sweden, Switzerland, the UK, and the US. She's done it all, really, in both ad hoc and institutional proceedings under all major arbitral institutions. Paula sits as an arbitrator in many disputes, very prominent arbitrator, and has been closely involved in several high-profile cases before the High Court of London, and also appeared before the Court of Appeal and the House of Lords, which is now the Supreme Court, and has become a QC in 2014. Paula is a towering figure in the world of international arbitration. She was appointed president of the LCIA court in May 2019, after having served as the vice president of the court for several years and on the LCIA board for a decade. She's involved with the ICC, BIICL, IDRC, ASA, ILA, and the Energy Institute, and is included in the AAA Energy Arbitrators list. Simply put, I will end on this note. Chambers and partners refer to Paula as brilliant. That is an understatement. and the most complete arbitration practitioner in London. Paula will be addressing us on the specificities of foreign perspectives to African seats, a very important perception and a very important presentation that I encourage you all to listen to. Next in line, I have Ehiribe, who is another great arbitrator and friend. He's a full-time arbitrator, adjudicator, and mediator, called to the Nigerian bar in 1982 and the Bar of England and Wales, Lincoln's Inn in 1996. He's a fellow of the Chartered Institute of Arbitrators, fellow of the Singapore Institute of Arbitrators, chartered arbitrators, qualified dispute resolver. He has acted as sole arbitrator, co-arbitrator, adjudicator, chairman of tribunals in several substantial cases under major institutional rules as well. He has, of course, one of the things that are extremely important. He has published a book on the Handbook on Arbitration in Africa, a Practitioner's Guide by Law International in 2013. Paula and Iki, welcome on board. I will introduce my last but not least speaker, Narcisse, who is the Secretary General of the Common Court of Arbitration at the OHADA Arbitration Center. He is a former judge, Secretary General of the Secretary General of the Court of Arbitration of the Ivory Coast, Côte d'Ivoire. As a lawyer, he was the consultant of the International Trade Center in Geneva. He teaches arbitration, alternative dispute resolution at the OHADA Regional Schools of Judges and at University in Abidjan. He is a trainer with firms in Paris and also former president of the Institute of Community Law in Africa. In 2014, he became the Secretary General of the Common Court of Justice and Arbitration of the OHADA and is Vice President of the African Association of Arbitration and Mediation Centers, ACAM, and a member of the board of the African Arbitration Association, the AFAA. We're delighted to have you on board again, my friend Narcisse, and he will be addressing us on the experience of the OHADA and the Common Court of Justice and Arbitration there. Iki will focus on general remarks about Africa as a whole and some case studies from 3 different English-speaking West African countries, namely Ghana, Kenya, and Nigeria. I think we're in for a treat. I encourage you all to listen and to engage during the Q&A session. We will start with Paula. Paula, the floor is yours. Thank you very much.
Well, thank you very much, both Mohamed and Stavros. I'm still blushing from that introduction. So let's get on to one of my favorite subjects. So arbitration in Africa, and I will focus, as Mohamed said, on Africa as a seat of arbitration. I regularly act for multinational energy companies, and disputes regarding their assets in Africa often arise. Arbitration is by far the preferred form of dispute resolution and has been for decades. But certainly I've seen a sea change in the last 10, 15 years. Previously, when I first started, it was very rare for the African counterparty to say, I want the arbitration to take place in Africa, or I want African governing law, and I want an African institution. But as economies in Africa have developed and the bargaining power has started to shift, we're seeing more and more often now that African counterparties are quite rightly saying, we want a link with Africa if a dispute arises. So a significant number of arbitrations do still take place in the traditional centres in Europe, Asia, and elsewhere. And certainly the LCIA, which I'm closely connected with, in 2019 had 10% of its arbitrations involving African parties still. But of course, much will depend on the bargaining power of the parties, where the asset is, the strategic importance of the deal. But it's fair to say these days, African counterparties are now insisting that as well as having an African governing law, the arbitration is either administered under African institutional rules and or the arbitration seat is in Africa. So let's look first of all at the institutions that are available. And I'll start with North Africa, not least because of our chairman today, but it's fair to say that the Egyptian capital is home to the oldest arbitral institution in Africa, the Cairo Regional Center, known as Zulficar. It was created in 1979 and by 2014 was regarded as one of the leading arbitration centers by the African Development Bank, and since then has gone on to record over 1,300 cases. In the most recent stats that we have available in 2018, the current caseload of Zulficar had 28 non-Egyptian parties and 17 foreign nationals participating as arbitrators. An alternative is Cairo. This is one of the newest African institutions based in Morocco, and it has great ambitions to open representative offices in every African capital and branches in Europe and the USA, so watch this space. Moving to East Africa, Rwanda has been a great success story, and the Kigali International Center has now registered over 100 cases. And in the last couple of years, it has indicated that 30% of its cases are truly international. There's also, of course, the Nairobi Center in Kenya, which now has over 40 cases registered under its rules and is having very positive feedback. Southern Africa has a number of options. Around 10 years ago, Mauritius made concerted efforts to become the preferred venue for African arbitrations, albeit that it is offshore Africa, has a new arbitration rule based on the UNCITRAL model law, forms a joint venture with the LCIA. But despite hosting the ICA conference in 2016, it didn't really take off. It's now relaunching. It's no longer in a joint venture with the LCIA, so we'll watch with interest to see if Mauritius can truly put itself on the arbitration map. But back onshore, it's fair to say that South Africa is really seeing a resurgence as an arbitration centre. Again, it's got a new law based on the UNCITRAL model law. AFSA, the local institution, has just launched redrafted rules for public comment, which have been based on advice from international practitioners from all around the world, but still also taking into account what African practitioners want to see in the rules. So let's hope that AFSA does launch those rules. They're seeing an increasing number of cases. West Africa as a whole has been rather slower to adopt the dispute resolution machinery that we see elsewhere around the world. But Nigeria is obviously the exception to this and is home to various arbitral institutions, often vying with each other to be the dominant centre. But obviously there is both the Lagos Regional Centre and the Lagos Court of Arbitration. In June this year, SOAS issued a survey on arbitration in Africa, and their top 5 arbitral centres on the basis of responses were AFSA in South Africa, Zulficar in Egypt, KIAC in Rwanda, the Lagos Court of Arbitration, and the Nairobi Centre. But what about African seats? So the most important question is, do you actually have a choice? There are certain countries that have mandatory rules about holding arbitration in country. Angola is an example. And certainly if you are moving in the oil and gas space, you can resolve disputes by arbitration, but they have to be in Angola, and the tribunal has to apply Angolan law and conduct the arbitration in Portuguese, which is the official language. So obviously that does cut down certain options. Another important issue is enforcement. And I think OHADA is an interesting option in that regard, and I'm sure Narcisse will tell us more later, but I just wanted to mention the reciprocal enforcement regime that it exists between OHADA member states. So if you've got a counterparty with assets in a OHADA country, you should seriously think about OHADA arbitration. And when you do have a choice, what other factors come into play? Well, if you're choosing the seat of arbitration, you're also choosing the local courts in order to supervise any proceedings relating to arbitration, be that seeking interim relief, or of course, if there's any challenge down the road. So you really want to think about, does the country have a modern arbitration law? Have the judiciary been trained to deal with international disputes and arbitration? A good indication is if the country signed up to the New York Convention, and certainly there's been great strides with African jurisdictions joining the convention in recent years. Obviously, countries like Egypt, Nigeria, and South Africa have been signatories for some time. But more recently, we've seen Angola, Cape Verde, and the most recent entrant, Ethiopia. Don't forget to read the small print, though, because although the Democratic Republic of Congo is signed up to the New York Convention, they made a record number of 4 reservations limiting its application. So in some ways, there is a chicken and egg challenge for African countries, because in order for their judges to gain experience and to develop the country's jurisprudence on arbitration, they need to be chosen as a seat. But of course, parties want to see a track record. Let's hope that over time, particularly those countries that are embracing modern arbitration principles, trying to train their judiciary, will see that move. So what are the preferred seats? In my view, and I'd be really interested to see what everyone else thinks, both on the panel and in the audience, the leading pack are South Africa, Egypt, and Nigeria. I've already, turning to South Africa first, I've already mentioned their modern law, the new rules that are coming out. It's also interesting, there's a new commercial court as part of the Johannesburg High Court, which is hearing all arbitration cases, and they're already showing a pro-arbitration stance in not interfering in arbitration proceedings. Egypt, of course, has got a very long-standing arbitration history, one of the early signatories of the New York Convention, signed up to a modern arbitration law, although there are a few differences to the UNCITRAL modern law. One example is if you want your tribunal to be able to issue interim relief, you must specify that. I'm not going to go too much further, otherwise Mohamed will be correcting me, and so I'll leave that to him. And then Nigeria, of course, lots of experienced arbitration practitioners, very active on the circuit, modern law, signed up to the New York Convention. Few wrinkles. Lagos has got its own arbitration law, which can lead to complications. But certainly I think from my personal experience that the Nigerian courts are becoming far more consistent in their approach to arbitration cases and exhibiting a pro-arbitration approach. There are delays, but when the decisions come out, they are well reasoned. So just to finish, what did the SOAS survey say about arbitration seats? Well, the top 5 cities chosen by respondents were Johannesburg, Lagos, Cairo, Cape Town, and Durban. So big South African preference, probably because people like going to those particular places. And then the top 5 African countries were South Africa, Nigeria, Egypt, Rwanda, and Narcisse will be pleased about this, Côte d'Ivoire. So to sum up, can Africa provide credible seats of arbitration? Yes, absolutely. And let's hope that that happens more frequently going forward, particularly when we can all travel again. Thank you, Mohamed.
Thank you very much, Paula. That was an excellent start. I'm sure there will be a lot to discuss during the Q&A. Without further ado, moving to Eke, the English-speaking part of Africa. Eke, thank you very much. The floor is yours.
Mohamed, thank you very much, as always. Well, again, I thank you immensely for the introduction, but first, before I forget, I wonder where you got that CV from. It sounds like a very old CV of mine, because it refers to me as a fellow of the Singapore Institute of Arbitrators. And secondly, it refers to me as a publisher of the text on arbitration in Africa, a practitioner's guide. Well, I wish I was, but I am not. I'm just one of the so many contributors to that seminal text. The editor is Miss Liz Bosman, who is from South Africa. So just to make that correction, but all the same, thank you for the introduction. I also thank the organizers for inviting me to take part in these discussions. These are necessary discussions that need to take place to deepen the involvement of African states in the practice of arbitration, be it domestic or international. Of course, I stand on all existing protocols. I know I have a very short time to deal with what is a very interesting and wide-range topic. And I said that because I spent quite a considerable length of time trying to deal with the parameters of the topic, which is Africa as a seat of arbitration and the involvement of local courts by way of support. Well, let me make the point. Africa is a large continent and with about 54, 55 countries and with varied legal systems impacted by different, should I say, influences, be it the French influence, the Belgian influence, the Portuguese influence, Italian and British. And what you will find, depending on which part of Africa you are involved in, is what applies in the north will not apply in the south. But I'm going to focus my discussions on English-speaking Africa, that is in both West and East Africa. And I say this because of my experience. And my experience is limited to accepting appointments as an international arbitrator and dispute resolver whilst based in London, but focusing on those English-speaking countries in Africa. And I mean Nigeria, Ghana, Rwanda, Kenya, and the Gambia. Now, the Gambia is a jurisdiction I wrote about, which I contributed to or for in the text that you earlier mentioned. Now, thinking about the topic compels an interrogation and a discussion of how African states have fared in support of arbitration. Now, I make the point, and this is going to be the theme of my discussions, that from my experience and exposure as a practitioner, regardless of what may be said elsewhere, in varying degrees, most English-speaking and progressive African states are supportive of arbitration and other forms of ADR. And I mentioned with a caveat, in varying degrees. And in varying degrees means to what extent these jurisdictions have been exposed to international arbitration. And I have the following jurisdictions in mind. Egypt, where Mohamed comes from, of course, is the leading jurisdiction. We've got Kenya, we've got Nigeria, Ghana, Gambia, Rwanda, South Africa, of course, Zambia, Sierra Leone, Uganda, Mauritius, and Tanzania. Now, correct me if I'm wrong, most of these countries are signatories of the highly successful New York Convention on the Recognition and Enforcement of Foreign Awards, 1958. And most of these countries also are signatories to the Washington Convention of 1965 on investment state disputes. Most of these countries are also have adapted in different forms the constitutional model law. So with that as the background, it supports the contention that there is progressive support for arbitration practice in these jurisdictions. Now, and there are a number of, if you like, milestones which have increased the progress rate of these countries. And the first one I have in mind is that since the publication of the 2015 Charter of Arbitrators Centenary Conference Principles, there's been a marked improvement in various countries. And those principles identify about 10 major factors or features that need to be taken into account to identify countries that have efficient and effective seats that support arbitration. And I'll just run through those 10 factors. The first is the presence of enabling arbitration laws. Second is a well-receptive judiciary, trained and well-informed in the nuances of arbitration, whether how the arbitration process takes place or enforcement. The availability of legal expertise to support the arbitration process in those jurisdictions. The continued education of practitioners in those jurisdictions. The right of representation, accessibility and safety, then facilities to support the arbitral process, ethical or ethics required of practitioners, enforceability, and finally, the immunity of arbitrators. Those are the 10 factors which the Chartered Institute of Arbitrators highlighted as the factors to take into account to identify efficient and effective seats. Let's hold that in one hand. Secondly, if we go to the SOAS survey on arbitration in Africa, which was published in 2018, it is said repeatedly that 55.7% of respondents rated their judiciary in respective countries as effective in rendering support to the arbitration process in their respective jurisdictions. That's a passback. Yes, of course, there's room for improvement, don't get me wrong, but that is indicative of continuous progress that has been achieved in the quest to increase and deepen the use of arbitration in Africa. Now, one other pointer in the right direction, if I may point out, is the fact that as a result of the colonial ties, most English-speaking countries have with Britain, you'll find that the Chartered Institute of Arbitrators in London has branches in most of these countries. And there is a vibrant, consistent effort to train and retrain aspiring arbitrators in those countries. That's again indicative of the presence of the availability of expertise in those jurisdictions where that speak English and are highly desirous of deepening the practice of arbitration in Africa. So that's that. As far those are general comments I seek to make. Now, I'm going to bore you with some detail, and the detail is as follows. In the last 18 months or so, I've been involved in about 18, not 18, I beg your pardon, I wish, 5 appointments from a number of arbitral institutions and international arbitral institutions. One of them, the first one is a Kigali-seated arbitration, and it will interest you to know that in that particular arbitration, both parties are represented by Rwandan lawyers. And I can tell you, without any fear of contradiction, that the lawyers representing the parties have discharged their responsibilities effectively, without any complaint whatsoever. I'm also involved in a shipping dispute involving owners of the vessel and charterers. The charterers are, and that's a London City arbitration under the LMAA terms, but involving a Nigerian-based charterer and Swedish-based vessel owners. The charterers are represented by Nigerian lawyers, and they have discharged themselves creditably in representing the parties in that case. I'm also involved in two other ICC cases. One is has to do with a dispute that originated in Ghana. The Ghanaian party is represented by domestic Ghanaian lawyers, and they've done very well. They're up to date with best international practices. And latterly, I've done a case in Nairobi seated arbitration, where again, the parties were represented by top-class, first-class lawyers. And I was just informed the other day that the decision I rendered has been recognized by the Nairobi High Court. So all of that is all indicative and demonstrative of the fact that there's huge support, positive and progressive support in these seats for arbitration. And this is my personal experience. And all of this is modern, is recent in the last 12 to 18 months. So, and this is from the point of view of a practitioner who is actually sitting in these jurisdictions or sitting or deliberating on disputes arising from these jurisdictions. So I want to make that distinction. I'm not acting as counsel, I'm acting as either arbitrator, co-arbitrator, or chairman of tribunal. And I want that taken into account to identify and signpost the fact that these jurisdictions are really coming up on the ladder. So now let's deal with a number of, for those of you who like cases, just to flag up the fact that there is judicial support and it's documented. And I think Paula mentioned a track record. For those who want to follow cases in that are demonstrative of how the judiciaries are in support of arbitration in these jurisdictions, let me start with first with a case that arose in Ghana. It's a very simple case, and I'm sure some of the participants will know about the case. It's BCM Ghana Limited against Ashanti Gold Fields Limited. A case reported sometime in 2006 in the Supreme Court of Ghana Law Reports. And it was simply a case where the Supreme Court of Ghana elected to enforce an arbitration clause contained in an agreement by staying proceedings where parties, in defiance of the arbitration clause, elected to go to court. And this is something that is very, in those days, years back, was quite prevalent in most jurisdictions. But that has now become, doesn't happen as frequently as it used to happen in those days. And this is as far back as 2005, and that's Ghana. Then in the Gambia, there's a case known as ESB International Limited and another against Utilities Holdings Corporation. As far back as 1997, the Gambian High Court, the Gambian Court of Appeal, unanimously rejected an application to frustrate the reference to arbitration on the usual technical grounds at the time that the parties had not entered into a conditional appearance and therefore lost the right to apply for a stay of proceedings pending the referral of the disputes to arbitration. And that's in the Gambia. Now back to Nigeria. One of my favorite cases that I like to cite in support of judicial support. And I agree with Paula, who has observed that sometimes these cases take time, but this is gradually improving. There's the case, well-known case of NNPC against Luton Investments and Justice Uche Omo, the arbitrator, where the arbitrator in this case elected to adjourn the hearing of an arbitral reference to London to take evidence from the appellant's witnesses, to which the appellant objected. Don't ask me why the appellant objected, but you can imagine why they did so. The arbitrator overrules the appellant's objection and therefore the appellant applied to remove the arbitrator from the arbitration. That application was filed before the Federal High Court, the Nigerian Court of Appeal, and the Supreme Court. All three courts in the land, including the Supreme Court, the final court of the land, dismissed the application in very robust terms. I say in very robust terms because counsel for the claimant in that case, NNPC, was giving a very negative commentary on what he had done. But that goes to show you to what extent the Supreme Court, and this is as far back as 2006, the Supreme Court rejected the application relying on Section 16 of the Nigerian Arbitration Act to hold that the arbitrator has full powers to decide the place where the arbitration proceedings shall take place. And that's a well-known popular case titled NNPC against Luton Investments and Justice Uchoma, the arbitrator. The second case, if I may, is a shipping case and is known as the owners of MV Lupex against Nigerian Overseas Chartering and Shipping Limited. And it's a case where, in that case, the charterers ignored the arbitration clause in the charter party and decided to file a suit in the Federal High Court against the owners of a vessel on the allegations that there had been a breach of the charter party. And they went ahead to arrest the vessel in question. The owners applied for a stay of the proceedings on the basis that there was an ongoing arbitration in London and the parties ought to abide by the arbitration clause in the charter party. Both the Federal High Court and the Court of Appeal refused to stay, but the Supreme Court held that the arbitration clause ought to be enforced as agreed by the parties. And this was as far back as 2003. So there's been a history of judicial support. And I'm giving these examples from Nigeria, Ghana, and the Gambia. So, and all of that is to make the point that gradually, increasingly, these jurisdictions are highly supportive of the arbitration process. Yes, there is room for improvement, but it cannot be said that these improvements will not come sooner. Now, just one further point I seek to make, and I think that this is a good opportunity to make the point. In most of these conferences that one attends, and from the comments that are made, it seems that the perception is put out there that the African states are in the dark. They don't, participants or disputants or their representatives do not know where to turn to find information. Well, I need to correct that impression. For those who are minded to do some further research, there are authoritative sources to consult, to seek information on different parts of Africa as it pertains to arbitration in Africa, be it domestic or international. And I'll run through a list of such texts which are in the public domain and published by publishers based in the Western world. The first of these texts, if I may, is a textbook known as International Commercial Arbitration and African States by a gentleman known as Asuzu Amazu. It was published by Oxford Publishers. And even though it was published in the year 2001, it encapsulates the history of the involvement of African states in international arbitration, be it commercial or investment treaty arbitration. And it traces the history or sheds light on the problems most African states had in embracing international arbitration and the practice of international arbitration, and how all those problems gradually petered away. Then, of course, is the second text which Mohamed referred to, and graciously described me as the editor or the publisher, which I'm not. I'm just a contributor. Is the text known as Arbitration in Africa, a Practitioner's Guide, edited by Liz Bosman. Now, the beauty of this text is that it deals with all parts of Africa, dealing with especially South Africa, Zambia, East Africa, West Africa, Portuguese-speaking Africa, and the OHADA region. And the beauty of this text is that all of these countries or sections are all in one place, one text. So you don't have to go to several textbooks to look for information on different parts of Africa, all in one, bound together. And then there's the more recent one, which is published by, it's titled Arbitration in Africa, and the title extends to read a review of key jurisdictions, and it's published by Miles, a well-known law firm in Nairobi, together with a very senior practitioner in Nigeria, Fagbo Unlu, SAN, and Kamal Shah, who is a partner in Stevenson Howard here in London. That's again another book which has in one place, in one volume, different aspects of arbitration practice, international or domestic, and from different parts of Africa, and is recent. I think it was published in either 2016 or 2017. And well, the other books, of course, on Nigeria, which I have about 4 of them here. One of them is by Mrs. Chinuade Oyekunle and Bayojo, a handbook of arbitration and the AGR practice. There's a second one, Commercial Arbitration Law and Practice in Nigeria Through the Cases, by Mrs. Rhodes Vivor. And there's a third one, who was the speaker yesterday, I remember. And there's a third one titled Commercial Arbitration Law and Practice and International Practice in Nigeria by Adeyemi and Olasupo Sashure. Those men were both, those gentlemen were both past presidents of the Lagos Court of Arbitration, as a very recent publication published in 2015. And finally, there's Commercial Arbitration Law and Practice in Nigeria by Professor Paula Donije, again, another recent publication published in 2015. And of course, from Kenya, there's another book from my good friend, Paul Ngotho, and it's titled Contemporary Issues in Arbitration by Paul Ngotho. So there isn't a dearth of material, if one is looking for it, to be informed as to what happens in both Kenya and other countries in Africa, be it Nigeria or Africa in general. So those are my few comments, and I expect that a lot of questions will be asked in the question and answer session, and I hope I have not overrun my time allotted. Otherwise, I think Mohamed would have cut me off, but I'm surprised he hasn't cut me off yet.
You went over, my friend, I have to tell you.
Oh, well, you're so kind.
I sent you a message.
Oh, well, I didn't read it. Well, but very well. Thank you very much.
Thank you very much. Thank you very much.
I'll keep that end here now. Thank you very much.
I think, again, a lot of food for thought. I'm sure that there are a lot of questions. Professor Bankole already has some question, which is interesting, and I'm sure, please prepare your questions because we intend to have a good Q&A. Now, without further ado, let me move on to Narcisse. I think I'm very grateful that he's with us today to share his experience. The working title of his presentation is The Common Court of Justice and Arbitration in OHADA, a one-stop shop. Narcisse, thank you. If we can, of course, limit this to 10 minutes so that we can give way for the Q&A, that would be great. Thank you so much. You are on mute. I think you need to unmute yourself.
Thank you very much, Professor Mohamed. It's a pleasure for me to participate in this conference. On behalf of CCGA, I would like to congratulate warmly all the organizers of this important event. What's the approach of CCGA OHADA to the support of arbitration? Why can I consider CCGA as one-stop shopping? It's particularly pleasant for me to briefly introduce OHADA to all our participants from English-speaking countries who do not have much information about our organization. OHADA was created in 1993, and the main mention is to harmonize business law in Africa in order to guarantee legal and judicial security for investors and companies in its 17 member states. Now we have 10 uniform acts in relation with business law. So we have the same mediation and arbitration law in all the 27 member, all the 17 member states of OHADA. CCGA arbitration rules have been adopted in 1999 and reviewed in 2017. The Common Court of Justice and Arbitration of OHADA is the key of the institution of OHADA. The CCGA consists of 13 judges elected by the Council of Ministers of OHADA for a term of 7 years. The court has its headquarters in Abidjan, Ivory Coast, but can sit at any other place in the territory of one of the 17 member states of our organization. The CCGA arbitration is an original system. The OHADA experience is particularly original. OHADA is, in fact, the only institution in the world offering a complete service from the request for arbitration to the post-arbitration step, which takes into account appeals against the arbitration award, in particular the annulment disputes and enforcement of arbitral awards. It's a really one-stop shopping for lawyers and investors. It's an arbitration center. Since the adoption of the new arbitration rules of CCGA in 2017, the court may also administer arbitral proceeding based on an instrument related to an investment code or a BIT or multilateral investment treaty. So now CCGA deals with investment and commercial arbitration. The majority, 12 countries of OHADA member states, adopted New York Convention. On the one hand, the CCGA is an arbitration center offering all arbitration services in accordance with international standards. It's a center open to Africa, but also to the world. Arbitrators coming from a lot of countries are involved in CCGA arbitration. The court appoints and confirms the arbitrators. We have a panel of arbitrators like Exceed. So the arbitrators may be selected by the parties or by the court from the list of arbitrators drawn up by the court and updated annually. The member of the court may not be included on the said list. It is possible to challenge an arbitrator because of the lack of independence or any other reason appreciated by the court. In the context of arbitration proceeding, our arbitration rules offer great freedom to the parties who can be represented or assisted by lawyers of a choice, whatever their nationality. It should be noted that more and more investors and states trust our arbitration system. To date, 6 or 17 member states of OHADA have pending proceeding. We have also some big company from Nigeria which have some procedure in CCGA. The court supervises the arbitral process while respecting the independence of the arbitrators and the party. But the CCGA is also a high and a Supreme Court, is the original system. On the other hand, the CCGA is the equivalent of a Supreme Court or the High Court in OHADA area. It rules on arbitral award litigation rendered by arbitral tribunal under the aegis of the CCGA. Now the rate of annulment of arbitral award is around 15%. As a Supreme Court, CCGA also rules on disputes relating to the annulment of awards rendered in ad hoc arbitration or under the aegis of other arbitration institution when the seat of arbitration is in a member state of OHADA. The annulment action against the award shall only be permitted for 6 reasons. If the arbitral tribunal has ruled without an arbitration agreement, if the arbitral tribunal was irregularly composed, if the arbitral tribunal ruled without conforming to a mandate with which it has been entrusted, if a principle of due process has not been respected, if a tribunal award is contrary to international public policy, if the award fails to state the reason on which it is based. Given the importance OHADA attaches to the promotion of arbitration, CCGA High Court shall render a decision of annulment within 6 months of a seizure. Regarding the enforcement of the awards, the executor shall be granted within 15 days of the filing of a request by order of the President of CCGA High Court. The decision of executor of the awards on interim and provisional measures shall be made within 3 days of the date of filing of a request to the court. The Secretary General of CCGA shall deliver to the requesting party an enforcement certificate. This enforcement certificate make the award enforceable in all the 17 member states of OHADA. It is possible for the parties to get this enforcement certificate only in the case of OHADA arbitration system available in the 17 member states of OHADA. It is the only system which allows this possibility to have an enforcement certificate for the 17 member states of OHADA. If the parties have another award, maybe an award coming from ICC or domestic arbitration center, it is possible to get an enforcement only available in the country. But in the OHADA system, if you have an award, an CCGA award, it is possible to get enforcement certificate available in the 17 member states of OHADA. Thank you for your attention, Professor Mohamed. I think I didn't, I respect the 10 minutes. Thank you very much.
Thank you so much. This is very helpful, and we are delighted to have you with us. I think there are a number of questions. The first one is an interesting question from Professor Bankole Sudipo, and I think it relates to the venue and the seat and place of arbitration. Perhaps if you would like to ask your question, otherwise I can share it myself, but happy to have you ask it. Or I can ask it myself, no problem.
Excuse me, Professor Mohamed, you have a question for me?
No, I think it's a question from Professor Bankole.
Professor Bankole. Okay.
Yes.
Okay. Yes, this is Bankole. Right. Now, some agreements make a choice of place where the arbitration can take place. Some mention venue. Venue and place can be assumed to be the same thing, but they may not mean the seats. And this was a major problem in the P&ID case involving Nigeria, where the panel had to determine the seats. Unfortunately, many African statutes do not specify what is meant by the seats. What are your thoughts on this and how this should be dealt with? And particularly where there's a choice of law that has designated an African state.
So, Paula, would you like to start with your comments on this, and perhaps then Ike and Narcisse can share their comments?
Yeah, very, very happy to, Mohamed. And I actually face this very issue in relation to an arbitration in Nigeria, relating to Nigeria, where Nigerian law was the governing law of the contract, and there was no seat or express seat specified. It just said, and the venue will be Nigeria. In that particular case, I'm very pleased to say the parties agreed to hold the arbitration in Lagos. We had a few procedural hearings in London, but the merits hearing was actually at the centre in Lekki in Lagos, and all went smoothly. But there could have been a real fight over that. Adopting an English approach, if the seat is not specified and you're in ad hoc arbitration, which we were in that case, you would then look to the seat with the closest connection. If you have an African law specified as the governing law, I think that would then play a big part in deciding the seat. It would also obviously depend on the nationality of the parties. If you're in institutional arbitration, obviously institutional rules often specify a default seat. So for instance, the LCIA, the default seat is London. But so I would encourage African institutions to specify a default seat in their rules, and then hopefully when it comes to jurisprudence, African countries will look again at their arbitration law and again either specify how a seat should be determined or have a default.
Thank you very much. Narcisse, Ike, you want to add something?
Just to say that in our system, if there is no indication about the seat of arbitration, the CCGA can choose the seat of arbitration for the parties. CCGA. And if in our OHADA system, generally in our OHADA Uniform Act, if there is no indication about the seat, the parties can agree and choose the seat. If a dispute arises, it is possible for parties to work. But if there is difficult in an arbitration, an ad hoc arbitration, the parties have a possibility to go to the court. And the court can help these parties to choose a seat of arbitration. But it's better to have an institutional arbitration under CCGA OHADA system.
Thank you. Actually, as well, in many African states now, the distinction between the seat and the venue, and I have to say, I think people now agree that you can choose the seat and the place interchangeably to refer to the legal connotation of the seat, which is the courts of primary jurisdiction, whereas the venue is different, where you can take one or more of the procedures, including hearings, held in a different location. And one specific important point to mention is that, for example, in Egypt, courts about some years ago were not accustomed to this distinction, which exists under the Egyptian Arbitration Act of 1994 in Article 28. which clearly distinguishes the seat and the venue. And more arbitration laws are making that distinction clear. But then, well, I personally wrote an article which was, to my surprise, read by the Court of Appeal. And in the next judgment, they made reference that the venue is a territorial link, whereas the seat has a legal connotation. And since then, courts have uniformly moved to make that distinction. And I think it's a very important point to note, especially now, when you have a seat of arbitration and people are holding hearings virtually or at different venues compared to what has been ongoing before COVID-19. And sometimes even now sophisticated parties make express reference to the venue, where they say tribunals shall be holding hearings or sitting in a certain location without making an express reference to the seat. So it raises a host lot of issues and challenges. Iki, is there something you wish to add on this front, or shall I move to the next question?
Indeed. I approach the problem from two angles. First, the problem arises from the choice of words used in the unsettled model law, which is lacking in clarity. And then second, the problem as it arose in the case in question draws attention massively to the need for transactional lawyers to ingest some clarity in the way arbitration clauses are drafted and be specific as to what they mean by seat, language, and place of the hearing to avoid this kind of problem rearing its head in the future. What has happened in the past is that inadequate attention has been paid to the way arbitration clauses are drafted, and this has generated the controversy that we now find in the PNID case. Thank you.
Thank you very much. There is a question from Elsina Jeffers. Perhaps she can be given the platform to ask a question.
Hello?
Hello.
Hello.
I'm worried about Africa and Black people because I'm a Black person myself. Somewhere along the line, we need to get Africa to look after Black people worldwide. Can this happen? Please.
Thank you very much, Elsina. Is there a direct tie to the seat, or is that more of a general question and concern about Africa and Africans?
Black Lives Matter. And in America, most Black people go into prison, locked up in mental institutions. So the question comes along, who is going to look after Black people if Africa don't look after Black people? As simple as that. A mechanism, and all these lawyers, I go to the Law Society and make laws also, and all these lawyers, who's not doing what? Am I supposed to get on my knees and beg? People got to do something. Thank you.
Thank you very much. Iki, what would you like to do? You were on mute.
Yes, I was listening to the question and I'm looking at the topic and trying to marry the question to the topic. Well, if what the questioner is trying to allude to is whether or not Black people participate in arbitration, well, you should look carefully into the participant list. You will see that a lot of Black people, including yourself, Mohamed, who are participating in arbitration. So there's nothing to fear in that. And as time goes on, there'll be more and more Black people if she's feeling that uncomfortable. That's all I have to say.
Thank you very much. I have a question for all the panel and perhaps Paula more in relation to international clients, because we can keep our discussion on the continent saying that, yes, we pride ourselves in having very good seats across the continent in many jurisdictions. Paula has referred specifically South Africa, Egypt, Nigeria, and we know that Rwanda, Kenya are rising to the standards and meeting people's expectations. But I think part of the negotiations we have with international clients is that even those centers that have been in existence for years on the continent show very promising prospects. The question that often surfaces is to what extent their permanence is at stake, and people include arbitration clauses referring to these institutions and seats in Africa. Is that still the case, or are people more relaxed on this issue, Paula? Thank you.
I've certainly seen amongst my oil and gas clients who want to have an enduring relationship with the African countries where they have assets, that they are willing to embrace both local governing law and institutions. I think there's a move away from ad hoc arbitration where possible to avoid the sort of issues that we were discussing a moment ago and that Ike mentioned. I've also seen, though, that there are other international companies doing business in Africa on a one-off deal that are much less willing to embrace having African dispute resolution. So I think it very much depends on the company and partly their negotiating power, but partly their commitment to their African investments. On the other hand, I've seen and been involved in an arbitration in London between two indigenous African companies. So I think everybody needs to show faith in the up and coming institutions so that they can develop the track record we've been talking about.
Thank you.
I think you've gone on mute, Mohamed.
Yes, sorry. Narcisse, is there anything you wish to say? I would like to give you the floor if there is anything you wish to add.
No, nothing special to add. Nothing.
Yeah.
If there is another question, I'm ready to answer.
Thank you. We've got 2 minutes before we close on time, and I'm very grateful for your excellent timing and contributions today. If I can ask each of the three speakers to say in 1 minute what their advice to African institutions and parties, what should they do to ensure that more arbitrations are seated in Africa, and perhaps even governments? Paula, in a nutshell, what would be your single advice to them in this respect?
I would certainly try and work with all the stakeholders in the country to make sure that they're signed up to New York Convention or maybe OHADA, modern arbitration law, train your judiciary, train your practitioners, get the practitioners coming to events like this, doing the Chartered Institute courses, so that there's a commitment to respect investment in the country and show that dispute resolution can be fair. If Singapore can get everyone pulling together in the same direction and catapult itself into being a very, very successful center, there's no reason why African countries can't do the same.
Thank you very much. Ike.
Well, I can't, Paula has said it all, but a different slant to it is this. African countries should continue these discussions, invest in training, CPD events is work in progress, and we keep on discussing these things. What will happen is that as international best practices are developing, whether it's in Geneva, London, Washington, or Singapore, it will also come home to African countries. So these discussions must continue, and that will broaden the practice and improve the practice all around. Thank you very much.
Thank you very much. Narcisse, what is your take on this?
I think we need two things. The first thing is promotion. We need to promote our system. We have modern law, we have a modern system, we have an original system, but we need to promote this system. The second idea is training. We have to train our practitioners. We have to train our lawyers to be able to be with all the businessmen, to be the good arbitrators. And training and promotion, the two words.
Thank you very much. And on my side, I would simply add the following. Independence, neutrality, and competence of the judiciaries are key to ensuring that we have proper seats on the continent, irrespective of who the parties are. With this, I think we are on time, and I hand it over to our organizers. And I thank you very much personally for all your contributions today and your presence. It has been a very enlightening panel. Thank you very much, Paula, AK, Narcisse, for all this. Thank you.
Thank you very much.
Thank you very much.
Thank you for your chairing expertise.
Thank you, Mr. Chairman.
I want to thank all the panelists and the chairman for a most incisive session. They've given a number of clues as to what to do going to the future. And the organizers will latch onto this, and we'll see for another 10 minutes before we have the last panel. Thank you very much.